Good evening, everyone. Thank you all for taking an hour out of your evening to be here with us tonight. My name is Tasha Bunch. I am the program director here at the Institute for Intellectual Property and Social Justice, and I'm very excited for tonight's IP for the People program. IP for the People in general is a program where we have legal experts in the field, generally of IP, but also of business and entrepreneurship, come in and talk to inventors, creators, and entrepreneurs about different topics as they are trying to go from idea to market. And so tonight's presentation will be on trademark law and specifically the trademark examination process through the USPTO. The topic for tonight is avoiding pitfalls in the trademark application process, advice from a former trademark examining attorney. Our former trademark examining attorney tonight will be Lauren Burke, who is currently senior trademark counsel at Jordan IP Law. She is also a proud graduate of Howard University School of Law, as am I. And soon, George will be as well. George Harris will be our moderator, and he is a current student, 3L student, with an interest in IP law at Howard University School of Law. And so, with that introduction, I will leave it to you all to take it away and have a wonderful program.
Thank you. All right, so hello everyone, and thank you for joining. George is going to be the moderator, and any questions that get put into the chat, he will ask. I'll have several points during this discussion that I will stop and see if there are questions. But again, thank you for joining. Thank you for the Institute for Intellectual Property and Social Justice for having me. As stated, I am a very proud graduate of Howard University School of Law. I have been practicing for about 17 years, which sounds crazy to say. I was formerly a trademark examiner at the US Patent and Trademark Office, and that is where all trademark applications get processed when people are seeking federal registration of their trademarks. So for purposes of this discussion, I will only be discussing the federal process. Trademarks can also be registered on the state level, and every state has a different procedure for how that works. I absolutely love what I do, and hopefully you find this fun and engaging. A brief overview of what I'm going to go over. I'm going to talk about what is a trademark, what is not a trademark, how to select a trademark, and also the federal trademark registration process. So to start, I am going to read the definition of what is a trademark as based on the Trademark Act, which is the federal law that governs trademark in the US. So a trademark is any word, name, symbol, or device, or any combination thereof, used by a person or which a person has a bona fide intention to use in commerce to identify and distinguish his or her goods or services from those manufactured or sold by others, and to indicate the source of the goods or services. Okay, so that was a lot of words, and I'm going to break down a lot of those concepts over the course of this presentation. But I'm going to start with the last part. Indicate the source of the goods or services. A trademark is specifically supposed to identify who is the manufacturer or provider of certain goods or services. And this is to protect customers so that they understand what they're buying and also anything related to the quality of what they're buying. And so this is where maybe you have a preference for Nike sneakers over Reebok sneakers because of the name Nike means something when it's associated with sneakers. This also protects trademark owners so that they can carve out their space and protect their brand for products that they produce, and to stop third parties from wrongly using those trademarks or even a similar trademark from being used with the same or similar goods or services. You're going to want this to be a distinctive mark, right? Something that sets you apart, because the trademark is an exclusive right to use that word in association with these goods or services, which is pretty powerful, right? Because it's a name it's the only name that is allowed to be associated with these goods and services. And it also essentially kind of forms a bubble of protection, because Nike makes sneakers, but if another company wants to use Nike and make socks, for example, well, it's still going to be confusing to a consumer, because socks are very much related to sneakers. And so Nike will have that protection against their trademark for similar goods and services as well. Now, there's various types of trademarks, right? So I said this also is for goods and services. So a trademark that relates to services is sometimes called a service mark, right? And so it may not be something tangible that a company provides. For example, FedEx or Uber. These are services. You can't necessarily go in the store and touch it or buy it, but it is a trademark that represents a certain brand that's associated with those services. A trademark can also be for what we call trade dress, and that is a configuration of either the product or the packaging for a product. And while I'm not able to share my screen, I printed out some trademark registrations from the US Patent and Trademark Office website as an example. So hopefully these are visible. This is a trademark owned by Coca-Cola. It is for a configuration of a bottle for soft drinks. This was registered in 1977, although it's been in use since 1916. So what does that mean? That means that this bottle is associated with Coca-Cola for soft drinks, and that no other company that sells soft drinks or even similar drinks, so if it was a juice or an iced coffee, this bottle is distinctive for the Coca-Cola brand and helps to represent that brand. Some other fun ones. Hermes has been in the news recently. This is Hermes's registration for its famous Birkin bag. And it's very specific as to the details of the bag. The description starts off, it consists of a configuration of a handbag having trapezoidal sides, a rectangular bottom, and a dimpled triangular profile. So again, this is a very specific bag that is only associated with Hermes, and will also be able to protect the company from other handbag designers from using similar bag or shapes of a bag. And another fun one, this is a trademark owned by Apple for an adapter. And so very simple, but most of you who have Apple products know this is what we call the block looks like. But you always know you can grab a block and it's going to work with your Apple chargers, right? So this is something that they've been able to carve out this space of, this is an adapter that Apple consumers will know they're getting an Apple product. A trademark can also be a slogan. Just do it, right? Nike's just a great example because it's a great brand. Have it your way. And you will know that's Burger King. It's used in their marketing, right? A trademark can also be a name or a surname. So I did some searching. Janet Jackson is a registered trademark, right? And so in her registration, she has some goods, stationery, book bags, but also entertainment services in the nature of live musical performances. So what does that mean? If your name is Janet Jackson and you want to go and perform under that stage name, well, somebody else, Janet Jackson, has that name as a registered trademark. And so it would be confusing for consumers if they see a concert advertised for Janet Jackson and it is not Michael Jackson's sister, right? So even if that is your legally given name, you would not be able to perform under that name because Janet Jackson owns a federal registration for providing those types of services. You see names used a lot in the fashion world. Calvin Klein, just an example. An important thing to note is that when a name is used as a trademark, there has to be consent from that individual, right? So Janet Jackson had to sign off and say, yes, I agree to my name being used as a federal trademark. However, you can also get a trademark for an individual who is no longer living. So one good example, great brand, John Deere, died long time ago, 1800s, right? His name is registered and there's a notation in the file that says this name does not represent a living individual. Well, that also doesn't mean that you can say, oh, well, I like this celebrity or this person and I want to register, their name as a trademark, even though they're not alive. Because there are right of publicity laws that could prevent that from happening, right? Their name still has some value to it, and there's somebody that manages their estate and their image. And so lastly, a trademark can also be a surname, right? One very popular one is Hollister. It's a clothing brand owned by Abercrombie and Fitch. And Hollister is also a very popular last name that several people in the United States have. Now, based on trademark law, a surname or last name in itself is not what we call inherently distinctive, in that there has to be some added proof to show, well, even though this is a last name, it does still function as a trademark or a brand name for my goods and services. All right, I'm going to take a pause there, see if we have any questions. All right, no, George? I'm going to keep it moving.
No questions right now.
Okay, cool. All
You also
right.
have access so you can share your screen too if you need to.
Oh, okay. Well, I think I'm kind of done with my demonstrations, but thank you. Okay, so next section. What is not a trademark? And this is probably my favorite section because there's so many questions I get about this and a lot of myths and confusion about what, a trademark is and what it isn't. So a trademark is not a copyright and it is not a patent. Trademarks, copyrights, and patents are all intellectual property rights, but they are all very distinct rights. So a copyright is a right that protects what we call original works of art or authorship. This would be contents of a book, a song, a photo, maybe even a dance. And it gives the owner the right to copy, display, or perform that artistic or work of authorship. A patent gives an inventor the exclusive right to make, use, or sell an invention that they've created. So the way that all of these rights can work together is that, let's say you have a toy you invented. So maybe you can get a patent for the toy, and then you have a name that you want to put on this toy to have exclusive use to use that for toys. So you want to trademark the name of your toy. And then you write a jingle that you want to use in the marketing of your toy, and you can get a copyright for that jingle. So that's kind of how all of those rights can work together. A trademark also is not necessarily a trade name. So a trade name is a business name, a name that a company does their business under. So, for example, we can have a ABC company. Well, ABC company could own a trademark for ABC, maybe used for some of their goods and services. It could also have a trademark registration for DEF or XYZ. Trade names are registered on the state level. And so you can also have businesses that exist in different states with the same business name because it's state specific. Now, when you do have a trademark right, that does not mean that no one else can say your trademark. It doesn't mean that there are royalties due if you say it or you use it in a particular way. You can use a trademark in a song, in a book. You say, oh, she was across the street from McDonald's, right? You're not using that word in a trademark sense to identify, sell, or market any goods or services. You're using it in more a descriptive or ordinary language way, right? As long as you're not endorsing goods or services under that mark, usually that can be fair use of a trademark. So you say, well, Paris Hilton used to say, that's hot. And she said she has a trademark for that's hot. So what does that mean? Well, Paris Hilton does own 2 federal trademark registrations for that's hot, but it's very specific what her rights pertain to. She has 1 registration that is for clothing. So she can make clothing with under the name That's Hot, and people will know that that's a product of something that Paris Hilton did. She also has a production services that she offers under the brand name or trademark That's Hot, which no one else can offer production services under that, right? So again, it is possible that trademark could be associated with something that's not even similar to those 2 things, but when it comes to those 2 specific items, they are associated with her and her brand. Sometimes there is a term that we would consider to be a widespread message. So for example, I started working at the US Patent and Trademark Office right after the incident that happened during the Boston Marathon. And we got an influx of trademark registrations for Boston Strong. It was kind of like the slogan of the times. And I guess, people wanted to capitalize on that. Well, that was considered a widespread message, meaning that there were so many people using the term that it didn't necessarily come to indicate the source of any goods or services, and that it would be difficult to know who actually originated that source, right? So if it's something that you want to say, oh, everyone is saying it, or it's just kind of used in, in the community, then it's likely not going to be able to get a trademark registration. And so without getting political, I just thought it was a good example because I saw this on the news. There were a few years ago, some Black men stating that they owned the trademark for White Lives Matter, and that they decided that they wanted to own this trademark so that they could police how it was used and to stop other people from saying it and using it. None of that was true, right? White Lives Matter is not a registered trademark. 1, it's a widespread message. 2, similar to what I read in the definition of a trademark, it has to be used by a person or which a person has a bona fide intention to use. So you can't file a federal trademark application and verify saying, oh, I'm using or intend to use this as a trademark if you really aren't, right? It has to be something that you intend to use, not just something you want to own so you can sit on it and try to police people from what they can and can't say. So that was incorrect. Another thing is that sometimes a trademark is owned, the same mark is owned by more than one company. If the goods and services are not related, then it is possible that they can what we call coexist. So I know this isn't interactive. I would ask for some examples, but there were two that I thought of. And so Dove is a trademark, a registered trademark. And most people, first thing that comes to mind is soap. However, Dove is also a trademark that is used with chocolate, right? And so there's no customer confusion there because most people are not going to think that the company that makes soap is also making chocolate. Another example of that is Delta. So there's a lot of brands you can maybe think of that have the name Delta, but two of the most popular, one is an airline and one makes faucets and uh, fasteners for sinks. So again, consumers are not really going to think that an airline is making faucets for a sink. And so there's no confusion, even though those two trademarks are the same. All right, give me 1 second, sorry. Okay. Next section. Selecting your trademark. So you say, I'm interested in potentially filing for a trademark. I have this product that I'm really excited about. I want to get out there. I want to use it. And I don't want anybody to be able to, capitalize on my name. So you want to pick a trademark for your brand. So the more distinctive, the better, right? You want to distinguish your brand from other brands that already exist and allow your trademark to stand out. So a good trademark is what we call a strong trademark, is more distinctive than ones that are not. So you want it to be as strong as possible. And there's kind of a meter that would be used in terms of most distinctive to least distinctive. So the most would be what we would call a fanciful trademark, right? That means this is a word that is completely made up. Pepsi, Clorox, Kodak, those are not words that, already exist. The company said we're going to make something up and that's going to represent our brand. Now, that's also not to say just because you make up a word, it's not similar to something that already exists, but it gives it a higher chance that it doesn't. The trademark can also be arbitrary, right? So it doesn't necessarily, I'm sorry. It's not necessarily a made up word, but has nothing to do with the goods and services that are provided. So a great example of that, Apple. We know Apple is a fruit. It has nothing to do with computers, electronics, or anything that Apple provides. Therefore, it works as a distinctive trademark. Same thing with Amazon. Amazon is a word that exists, but has nothing to do with the services, the goods or services that Amazon provides. There's also suggestive trademarks, right? So these don't outright state any qualities of a product or service, but it gives you an idea. And so a good example of that is Coppertone for suntan lotion, right? So it's suggesting when you use our product, you'll have a copper tone, but that's not really giving a lot of information about what the product actually is, right? You want to stay away from directly describing the goods or services because the closer that you get to that, which is what we call generic, the less likely you are going to be able to get a trademark registration for that, because again, you're getting the exclusive right to use this. And so you can't exclude others from using a word that would be needed to describe a good or service, or that would just not indicate anything distinctive about the source of these goods or services. So right at the bottom of this meter is descriptive, right? Here's where it does describe a characteristic or a quality of these goods and services, but it's still not what we call generic, right? So you might add a bunch of words that are descriptive, and I have some examples. The Counseling Center of Virginia is a registered trademark, right? It says very, very clearly, well, this is a counseling center in Virginia. Nashville Lager is for alcoholic beverages out of Nashville, right? 1 Hour Shades, also registered trademark. It's kind of clear what they offer, but it's not necessarily what we call generic, because 1 Hour Shades doesn't exactly describe that product. And lastly, Empire State Warranty is a warranty company based out of New York. So you can get a trademark registered for these. It typically does not have the same rights in terms of how you can enforce these trademarks against third parties, right? So there may be some words in your trademark that other parties can also use because they are so commonplace and they do describe the goods and services, but all of those are registered trademarks, so it is possible. Now, what's not possible is a generic trademark, right? You produce tires and you want your trademark to be tires. That's not going to happen. You can put a more distinctive term in front of tires. You won't have rights to the term tires itself, but you would have protection for any word that was distinctive put before tires. Okay. I'm going to take another break, check in with George.
Hey, we do have one question.
Okay.
Oren Williams is curious about when should you start the trademarking process?
Great question. So it's as soon as you have an idea that you might want to do this, you can start looking into it. This is something that comes up a little bit later, in that when you file your trademark application, you do not have to be using the trademark already. You can do what we call an intent to use, right? If you file an intent to use trademark application, you are verifying that I have an intention to use this trademark in association with these goods and services at some point in the near future. Once your application is reviewed, if you get to the next step, you will have up to 3 years to provide proof of how you're using that trademark with those goods and services. If during those 3 years you're not able to produce that or do that, you can refile at the end of the 3 years and start the clock over. But it does give some time if you want to do any type of, brand development, market studies, anything with that. You can do that before you start the trademark process. So it's really, if you really think that you have a name that you feel very strongly about, that you think you are going to use or you want to use. What I was going to bring up in my next section on trademark searching, that's really the first part of the trademark application process, right? We've talked about the selection. Just because you've selected a trademark that you think is going to be good, you don't just go for the next step like, oh, I'm ready to apply, right? You have to do a search. And this is a large part of the process because, again, a trademark is giving an exclusive right. So if somebody already has the right, you are going to be denied that opportunity. So you should also do all of these steps before, doing any branding, any product development. I have had clients come to me and they had this good idea and they went out and they started selling goods, and then they get a cease and desist notice from someone that owns the trademark, and they're like, hey, we see that you're selling these goods under the same name or a similar name where consumers would think that you are us, and you need to stop. Right? Because trademark rights in the US are based on who used it first, right? Even if someone has been using their trademark for 30 years and they just applied today, they have the opportunity to put on their application when they started using it. And so they would have superior rights in terms of getting that trademark registered. So you want to do a trademark search. Look on Google. There is a system set up on the USPTO's website. I will say that this is also where you might want to get a lawyer, because it's not as simple as, well, that the marks have to be identical in order to be considered similar. And that's where a lot of people kind of get lost in the process. And so part of the value that I add as a trademark attorney is I can do that analysis and set up a search that, well, maybe there's a mark FOUR. Maybe you want to search and see if anything is registered with a PHOUR or PHOOR, right? Something that might have a similar, what we call commercial impression. Would a consumer think that they sound or look similar? And are the goods and services similar? Right? And so that's another thing, is looking at these goods and services is also kind of knowing the market, but also what we call the natural zone of expansion. And so I'm getting a little out of order, but I'll go there to say a mark was recently rejected, door dabs. It was delivery of medical cannabis. And it was refused because of the DoorDash trademark, right? Which already is a delivery service. Now, DoorDash delivers food, convenience items, maybe even some alcoholic beverages. Would someone think that DoorDash was associated with DoorDabs for delivery of medical cannabis? Sure, right? I think that's a pretty reasonable rejection. And so again, someone searching when they're looking to register this DoorDabs to know DoorDash is already in that space, there's a certain analysis that goes on to determine, oh, well, am I likely to get refused if I file this trademark registration? So you want to do a search that looks for similar words, but then again, a trademark can also be a slogan. It can also be a logo, right? And again, a slogan doesn't exactly have to have the same words. It can have a similar impression. And a design search is, that's a totally different beast. There is a whole system of how designs are coded in the US Patent and Trademark Office system, how you search them, and to look for similar designs, right? Just to give you some examples of how a trademark could still be considered similar, even if it doesn't seem that way generally from the outside, or something that you could potentially miss in a search. There was a trademark, Pickwell Farms, PICK Well Farms for vegetables. And there was Picked Sweet Farms, PICKED CTS Sweet Farms. Those trademarks were found to be similar because they both especially when the goods are identical, so there's not even any confusion as to what they're producing. You have two vegetable companies and the USPTO said, well, look, these seem similar enough. First of all, they do both have farms. Would a consumer maybe remember that someone says, oh, I got these great vegetables from Pickwell Farms, and then they go to the store and they say Pick Sweet Farms? There's a chance that a consumer could get confused between those two brands, and it not really maybe glaring that they are similar. Another example, Sage Fourth for medical services was found similar to Sage Central. So this can also come up where a particular word is very distinctive for the field that it's in. So if there's only one other company using Sage in their trademark for medical services, then almost anybody else that comes in that has Sage, even with additional wording, is highly likely to be found similar because this company is so distinctive in this space. Now, there is a concept called famous marks, where sometimes, even if a brand is not in a certain space, or it doesn't even seem like a natural zone of expansion, that they can have like more of an overarching trademark right because the brand is so established. This would be based on proof provided, like volumes of sales, how much are spent on marketing, the duration of the use, and also a lack of third parties using the mark. So I'm going to go back to one of my favorite trademarks, like I said, Nike, right? So right now, Nike does not have any trademarks in the food space. But if a sports drink or a power bar or some kind of health bar came out under the name Nike, you're probably going to think that it's from the same Nike brand that makes sneakers and everything else sports related, right? And so even though they're not in the space, Nike would have a really good argument to say, well, we've been using this brand, we own this brand, and it's very highly likely that consumers would think that we produce these products. All right, so that's what I got on trademark searching. I am going to go into the actual application process next. Any more questions, George?
Yeah, I have two more.
Okay.
So one question is it better to file a trademark alongside a logo or as a logo, or is text sufficient? For example, Nike versus Nike with a swoosh.
Okay, good question. Also coming up in my next section. So, what I tell my clients, if they have wording and a logo, I would advise filing two separate applications. Why? That gives you the freedom to get protection for just the word Nike or just the swoosh on its own. And you don't necessarily have to use them together because as I was going to explain, one of the pitfalls of the application process is that the drawing that is submitted on the trademark application is how the drawing needs to look when you submit proof to the USPTO on how you're using that trademark, right? And so if your drawing is Nike above a swoosh, and then you provide proof and it's got the swoosh over Nike, that's going to be rejected, right? The drawing is very specific as to how you're using the mark, down to color and any detail. So you can file a trademark, especially a design, and not claim any colors. That's helpful because if you one time want to put it in red writing or put your design in red and then another time change it to orange, you have overall protection for the actual design. And so it won't matter what color you use. Similarly, there's something called standard characters for words where you're not giving any characterization to capitalization or any stylization. You just want this word registered, and you want the right to use it in all caps if you want, or lowercase if you want, perhaps even diagonal, could be applicable, and any color, right? So there's something called standard character that you can choose, and you'll have the right to just get a trademark registration for that word itself, it's a very, very broad protection. And I would always advise starting there, even if you want to follow up and do later registrations that maybe you do have a color, maybe it's a color that has become more distinctive to your brand and you want to get it protected exactly in that color. That's possible as well.
You had two more questions.
Okay.
Can a color be trademarked like red bottom shoes?
Interesting. So there is a trademark. So a lot of people know Christian Louboutin. That is, you see a red bottom, it is associated with a certain good, right? Now there was a case that came out, I cannot remember the other brand. They were making shoes that were all one color, right? So it would be green with a green sole, orange with an orange sole, and they made a red shoe with a red sole. And what the court decided was that the right to have that red bottom, it has to contrast the top of the shoe. So yes, the red bottoms on Christian Louboutin shoes are trademarked. As you know, you don't want that. I mean, it's one of the most popular shoes there ever was, right? And so he's been able to do that through this trademark because nobody else can do that. When you see a red bottom walking down the street, oh, I know exactly what kind of shoe she has on. I can go to the store and get them myself.
Last question. Can you briefly discuss ornamentation in trademark use or when decoration does not constitute trademark use?
Yes. Okay. So ornamentation is use of a trademark where it is used in a more of a design element rather than as a source of goods or services. So, for example, on a t-shirt, if you have wording largely written across the shirt, that name could have been printed on the shirt. The tag might actually say Hanes, right? But you can print your trademark on these shirts and sell them. When you go to register, though, and you say, oh, I'm selling t-shirts, this is my trademark, you will likely get a refusal that says, oh, no, this is an ornamentation, you know, and it's not that you can't get the trademark for it. It's then one of those ones that we would say is a little bit more descriptive, not necessarily inherently distinctive. So you will have certain less rights when it comes to enforcing that trademark, but it can still have the opportunity to be trademarked. It's more like over time, you will have to show that consumers associate your brand that you've just simply been printing on a shirt rather than using it more as the producer of a shirt. Hopefully that makes sense. It's a complicated concept. All right. All right, so now we're going to get into the actual process. You're ready. You've picked your trademark. You've done your searching. You're like, I found a good one. I'm ready to go, right? So you go on the USPTO. It's uspto.gov. The Trademark Electronic Application System, we call it TEAS for short, TEAS, is the name of the system that you're going to use. Immediately, first question. Do you want to file a TEAS or TEAS Plus application? This is probably the first time that you can get tripped up in the process, because what is the difference between the two? Now, TEAS Plus costs less. You say, oh, well, I want to go with the cheaper option. Well, why does TEAS Plus cost less? Because there are certain requirements that you have to put on that application. Essentially, they make it easier for the trademark examining attorneys to look over the information that you provided. So, for example, there is information that you have to include in a T's Plus application in order to get the benefit of paying a lower cost. So we said that these trademarks are registered in the United States, but they don't necessarily have to be English, right? So you want to trademark a word that's maybe French or Spanish, that's fine. Well, if there is an English translation of that word, you have to indicate that in a T's Plus application, or else they are going to come back and say you did not do all of the requirements for this application, and you will owe the additional money as if you never did this type of application in the first place. Now, the difference right now is about $100. Very interesting timing for this presentation because the USPTO fees are going up this weekend, and there is going to be a charge even for regular T's applications if you do not select certain things. So I'm going to go into a little bit of that. For the T's Plus, you also have to put a color claim if there's a color, a mark description if there's any type of design or stylization. Most importantly, the ID, which is the identification of goods and services, right? You want to specifically state what those goods and services are. There is an ID manual that you can access online. When you're filing a T's Plus application, you have to pick an ID that is already stated in that ID manual. You cannot make up what we call free form text and say, well, this is how I want to describe my goods and services. You have to pick a pre-formatted description of your goods and services. Again, not following any of these will what we call kick you out of T's Plus, and your application will still be valid. You'll just have to pay more money. So again, going forward after this weekend, even for the standard T's application where you don't have these requirements, if you do not pick an identification of goods or services that is from the ID manual specifically, you will owe more money than you owe today. So I've been trying to encourage my clients to file as many things as possible. Not often we get these big changes, but this is a big thing that's going on with trademarks right now. We talked a little bit about intent to use versus use. So again, you have to indicate whether you are already using these goods and services. You will have to identify the date that you started using them, since the rights are going to be granted based on when you started. And if you're already using it, you have to show proof, what we call a specimen. And so that can be a screenshot from a website. It could be an actual physical picture. I used to love talking to the older trademark examining attorneys when I worked there, because back in the day, you actually had to mail in and they would receive these things in the mail. But thank goodness for technology, right? One very important thing to remember throughout this entire process, all the information is public, right? You are going to have to put a name, an address, a phone number. Now, phone numbers and emails are usually hidden. But all of the information that you are writing, any communication that you might have back and forth with the USPTO, it's visible, because this is all a process that, again, the public needs to know about because it concerns them, but also people who are already using trademarks need to know this information. So if I see that a trademark has been filed for something that's similar to my brand, whether I have a trademark registration or not, if I say, oh, I've been using my trademark longer than them, there's a process that I can institute to come in and say that, right? So I know I'm running short on time. I'm going to go into just 3 big elements that usually people run into issues with these applications. The owner, right? who owns this trademark? It can be an individual, a business. If you have two individuals, maybe you guys are, working together, there can be joint owners, but you need to correctly identify who the owners are, right? So a big error that people make here is that the entity and the name don't match. So you're filing under an LLC, but it says it's an individual filing, or sometimes vice versa. There's an individual's name and it's saying, oh, this is a limited or a LLC, right? That is something that is not fatal, it can be fixed, but it's something that you should watch out for. Now, what does become more problematic is if you say, oh, well, it's under this name incorporated, and that's not really a corporation that exists. Maybe you meant to put LLC. There's some issues there with then stating, whether that you actually had the ability to file under someone else's name that was actually an established corporation. I spoke about the drawing, when you have to submit what this trademark is actually going to look like. There's a lot of cases where a trademark, like the drawing says, can be changed, but there's a lot of times where you're not allowed because it would be what we consider a material alteration. So an example, if you file for New York Jewelry Outlet, and then you're like, oh man, later on you say, well, I just want to use the initials NY. That's actually a case. You can do NY Jewelry Outlet instead of New York Jewelry Outlet, right? Maybe you filed and there wasn't a space between two words, you want to add a space. A lot of times that can be admissible. However, if it changes maybe what we call the commercial impression or how this mark may be viewed, got milk by itself and got milk with a question mark, that is not something you say, oh, it's so simple, it's just a question mark, or remove a question mark. Well, those two things mean something different and they're perceived differently to consumers, and it's not likely that would be allowed. And lastly, it's going to be your selection of goods and services, right? This is a big area that, again, could be fatal for a trademark application. You have to specifically identify your goods and services and put it in the correct class. There are 45 classes of goods and services, and all of them are they have different classification headings, right? So you want to get the right class, you want to get the right goods, and even if you put some in the wrong class, that is something that maybe can be fixed. But what can't be fixed is, let's say you own a company that does imprints of designs on shirts, right? People bring their shirts to you, you put these imprints on, and that's the service that you're providing. Well, you come in and you say, well, I sell t-shirts. Well, unfortunately, that's not actually what you're providing. You're providing the service of imprinting on these t-shirts, not the t-shirts themselves. So that is something that would be an error, and there's no way to fix that. You would have to start the process over, pay the money over. Additionally, if you ever wanted to broaden the types of goods that you're offering. So you come in, your trademark registration says, oh, well, I want to make cartridges for 3D printers. But then you decide, well, I really want to do just general cartridges for printers. Well, unfortunately, you were very specific when you said cartridges for 3D printers, and that's what you're going to need to provide proof of that you're actually using this trademark with. So, again, it is a very technical process, but it's not impossible. A lot of people file their own trademark applications on themselves and get registered trademarks, but there's a lot that goes into it before you get the final result. So I think I'm just very close to time. I did want to leave a little time if there's any more questions.
Do trademarks expire?
Yes, they do. So you have to maintain a trademark, right? Once you get the registration, you're good. For the next 5 to 6 years, you won't hear from the USPTO. And then you will get an email and they will say, we need to see proof that you're still using this trademark. So the initial proof comes between the 5th and 6th year after your registration. You have to provide the same type of specimen that we talked about, a picture, a screenshot, signage, a business card, something that shows, yes, I'm still using this. And of course, you verify, sign, submit it. After that, at the 10-year mark, you will have to file more proof. And then after that, it's every 10 years. So if at any point during that process, you cannot provide proof, you will lose your trademark. It will be canceled. Additionally, you will have to provide proof that, or at least verify that you are using the trademark for all of the goods and services that are included. So if you put 5 types of piece of clothing that you produce, but now you don't make shorts anymore, you need to delete shorts from your identification of goods. Which if you don't, there's now a procedure called an audit where you can randomly be selected and the office says, okay, well, you only, you provided proof that you're using this mark with t-shirts. We see that you said you're using it with all these other goods, but show a specific proof for the shorts. And if you can't do that, there's a fee for that and the shorts will be deleted from your registration.
I have a few more questions.
Okay.
If you start a company and trademark it with one product and years later you want to add another product, do you start all over?
Yes, typically. You want to get on record all of these goods and services that you're providing. And so that's why sometimes on the outset, the fact that you can do an intent to use, if you have an idea that you want to provide these in the future, you want to add them then. If you want to add something later on, you do have to start the process over. This is also another reason why you want to be as broad as possible, right? So that if you produce something in the future that can kind of fall under the umbrella of what you already have protection for, then that can help and you might not exactly need that new registration.
Next question. When one infringes on a trademark, what are the different remedies the person who has been infringed upon have?
Okay, this is something that there's a few different procedures. The USPTO has something called the Trademark Trial and Appeal Board, which is a panel of 3 judges that if you believe someone has filed an application or even has a registration that is detrimental to your brand, there are cancellation and opposition procedures that can happen there. There are also procedures that can happen in federal court, right? So a lot of times people like to go through the Trademark Trial and Appeal Board. It's um, less money, sometimes less involved, and you can get the other trademark canceled, or if it's just pending, you can stop it from pending. If you go to federal court, you can get money damages, perhaps if you have any loss of income from the time that this person was selling their product, that they wrongfully used your name, and got consumers to send them money that they didn't send to you. You can do that in federal court.
And two more. So how can I become a trademark examiner?
Well, it's a job, I want to say like any other job, you have to apply. You don't necessarily need any trademark experience. USAjobs.gov is where you would find when they are hiring at the US Patent and Trademark Office. One good thing to know is that USA Jobs has a feature that they let you set alerts. A lot of times when there are job openings, they don't stay open long. So you might want to set an alert so that you see when those are open and how to apply.
And last question, if someone's interested in contacting you outside of the seminar, how could they reach out to you?
Sure. So I am on LinkedIn. You can find my name on there, Lauren E. Burke. And also my email address, my current position is lburke@jordaniplaw.com. And I would be happy to answer any additional questions or any concerns. You have anything that pops up later, or you would like to utilize my services, I'd be happy to help you. So sorry for running over, guys. But hopefully I did get to everyone's question. Here's Tasha.
Thank you so much, Lauren and George. That was a great informative program. And thank you so much to our audience who's very engaged and asked some great questions. I have to admit, I was going to slide in like a sample question or something like that, but there was absolutely no need. You guys were on top of it. I hope you all got a ton of great information out of this session. We will follow up in the next few days with an email letting you know about other webinars that we've done that you can take a look at over the next couple months. This will then be posted on our YouTube page in case you missed something and you need to go back. You can always look at that posted on our YouTube page, and also, follow us, the Institute for Intellectual Property and Social Justice, or IIPSJ for short, for future information on IP law. Our next session will be in April, and it will focus on copyright law. So for all you creators, musicians, if you write comic books, anything like that, you might want to come back and check us out. Thank you all so much for joining us tonight, and everyone have a wonderful evening.